it right. Lorcan Tiernan. 3 years ago, we had a Celtic connection, Katerina Gardner, and it was a wonderful connection. I think Professor Johnson thereafter worked with her in one conference, perhaps in London. Well, it matters not. But some nice connections were made here. So we want to welcome our seasoned solicitor from Dublin, Ireland. Lorcan practices in the leading Irish law firm of Dillon Eustace, where he became a partner in 2000 and head of its corporate and commercial department in 2004. I could say much more. But to abbreviate this, he's a member of the International Bar Association and co-chair of the American Bar Association's International Finance Products and Services Committee. So he's come all the way to Dublin. He's going to be our first speaker. We're going to say, take 25 minutes thereabouts and tell us about practicing in Dublin, and perhaps end on a note with respect to payments on international deals. Then Professor Sarah Jane Hughes. Now last year, some of you will recall, we had Professor Amy Voss from Drexel. I phoned last winter and said, whom should I call to talk about current challenges in regulating emerging payment systems and related issues, inasmuch as I had begun to read words in the Wall Street Journal that I didn't understand. Virtual currency, Bitcoin, all that kind of thing. So I contacted Professor Sarah Jane Hughes at Indiana Law School, and she agreed that she'd come. She's come a long ways. In doing a little research, I note that she graduated from Mount Holyoke College, where my daughter went to school, and then the University of Washington School of Law, and she teaches the real stuff: sales, negotiable instruments, secure transactions, regulated industries. Now, another just short observation. The research, the reference people down in the library printed a number of our articles for me. And I just make a reference to an article in 32 Yale Law Journal on regulation, I guess it is. And just look at the contents. Regulatory approach to cryptocurrency intermediaries, right? State laws regulating money transmitters, money services business, and all that kind of thing. I'm not quite sure what that means, but she is currently, as I understand it from Steve Chow, that she has an appointment with the Uniform Law Commission to draft a statute, which I think will be titled The Uniform Regulation of Virtual Currency Businesses. Law in the making. Then a few words about Professor Steve Chow, Attorney Steve Chow. He's also adjunct professor. Many years at Suffolk. He's a partner in the firm of Burns and Levinson. Prior to that, he was in the firm of Perkins Smith and Cohen. He was appointed by Governor Weld in '94 to be a commissioner, has been reappointed. I think by common consensus, he knows about as much about the work of the Uniform Law Commission as anyone. And now, lastly, I'll make mention of Professor Steve McJohn. Of course, these bios are in the program. His bio, quite abbreviated, is at page 10. He studied, as have three of our other panelists in Germany, held a federal clerkship, practiced with a firm in Chicago, taught at Chicago Kent, and then came to Suffolk. Now he's become a co-author on Professor Douglas Whaley's commercial law casebooks, and also, I want to say he was very kind to come over last winter and teach a course, a full session on a UCC Article 4A on funds transfers, on which he's made himself an expert. And I'm not an expert. My students enjoyed it. I'm not quite sure how I'll ever reciprocate, but in some small way, maybe I can. Now, a change from the way we did the program. Lorcan Tiernan will begin, as I said. Then, rather than Steve Chow moderate, it'll be Professor Steve McJohn who moderates, and it'll be somewhat of a freewheeling discussion on, virtual currency, Bitcoin, emerging payment systems. How do you regulate these? Steve McJohn can coordinate and run with it, and we can certainly take till 5:45. Thank you.
Thank you, Gary. Good afternoon, everybody. As Gary said, my name is Lorcan Tiernan. I've travelled from Dublin, Ireland. I'm delighted to be here. I'm very honoured. I think I'm here probably representing two different constituencies. One is your largest trading partner, which is the European Union, and the other is something I learned for the first time today. One of the CISG holdout states, being Ireland. And I have to say, I sat there and I wasn't sure whether I was feeling good that I was one of the 82% of judges who had no idea what this was all about, and I was feeling slightly chuffed, or the 70% of practicing lawyers who knew little about it. So I was delighted when Michael put me out of my misery and told me that we actually haven't dealt with this in Ireland at all, so that was a slight relief. I didn't doze my entire way through university. I think because I've travelled the furthest, Gary has given me extreme liberty to speak to whatever it is I want to speak about, so I'm going to take advantage of that, and I hope you'll bear with me. So there'll be a little bit of history thrown in here, a little bit of trade, some European law, and really what I want to try to do is give a context from a European lawyer from one of the smallest countries in Europe, give a kind of perspective on international trade, where Ireland sits in it, why Ireland sits there, the small little cog in the wheel that we are, and maybe to give some thoughts on some of the larger issues that are facing us globally from a trade perspective. Gary also asked me just to speak briefly about the firm, which I'll do, just to put us in context, maybe a little bit about our work with the American Bar Association. So maybe to start with that, the firm Dillon Eustace is a relatively young firm. I don't mean we're young, but the firm itself hasn't been around that long. It was set up in 1992, so we'll be celebrating 25 years next year. And it has grown as a firm very much in line with our country's financial services industry, which I'll talk about a little bit later. And if I was to put a title on this presentation, it might be International Trade Punching Above Your Weight, something to that effect. That I don't think I've punched anybody in my life, but maybe once, and that didn't work out so well, so I've never punched anybody twice in my life. But I think the theme is that a country like ours, due to the breaking down of international trade barriers, can actually punch above its weight. As a firm, one of the ways we do this is we travel, we get out there, we cross borders, we get to meet people, we join organisations like the International Bar Association and the American Bar Association. And what do Irish lawyers do in the American Bar Association? Well, there is an international law section, which is a very significant part of the ABA. There are thousands of lawyers from every country in the world, members of that section of the American Bar Association. The committee that I chair focuses on international financial services and products. And I was very interested to hear the previous presentation, because one of the initiatives we're working on at the moment is to promote the whole area of microfinance in developing countries. So our committee is, I suppose, in a way, crossing that boundary between business law and human rights, recognising the benefit of finance to the less well-off in developing countries as a way of lifting themselves out of poverty. That, and we go to nice conferences, not quite in Geneva, but we get to travel and meet people, and get a great benefit out of that. So can I just ask a question? Hands up. Is there anybody here with a drop of Irish blood in them before I keep going? Okay, that's what I kind of thought. I said if nobody puts their hands up, I said, John, the litigator in the audience, you should never ask a question unless you know the answer to it. But I thought I was on pretty safe grounds. So let me tell you maybe a couple of things about Ireland that you may not appreciate or may not be aware of. Ireland is a huge financial services centre. Over 50% of all leased aircraft in the world are managed through Ireland. And to give an example, we administer close to 3.5 trillion euros of assets in mutual funds are administered in Ireland. For a period, we were the world's second largest exporter of software. We are the headquarters for Apple, for Google, Microsoft, and large companies like that who have set up very significant operations in Ireland. We have, and this was new to me, but we have more actuaries per capita than any other country in the world. Yeah, and they call us the Fighting Irish. There we go. And we have over 40,000 people employed in cross-border financial services. And these are pretty significant, I think, to a country our size, figures and facts. And it got me to thinking as to how we got there and how did Ireland develop this this kind of ability to punch above its weight, if I can put it like that. So you look back at our history, and here's the history lesson. And we missed out on the Industrial Revolution in Ireland. We had very much an agricultural-based economy, hence why there's so many of you here. We spread out, and we had to. We were dominated by a larger neighbour. That's all fine, that's all good, and we're all friends now until they vote for Brexit. We're not feeling too happy about that. But we fought for independence. We got there. We were an insular state. 1922, we gained our independence, and like any young state or nation, we made loads of mistakes, did things the wrong way, and eventually started to do things correctly. And probably one of the best things we ever did, and the biggest and best decisions made by our politicians, was to join the European Union in 1973. So the European Union itself, to continue the history lesson, is really a fascinating organization. It grew, as you probably knew, out of the Second World War, when the leaders of the large European countries were punch drunk. They said, we can't just keep doing this to each other. We can't keep pulling our continent apart. And ironically, Winston Churchill was one of those initial visionaries, and this led to the creation of the European Coal and Steel Community in the 1950s, not that the UK was a party to that, which then led in turn to the creation of the European Community in 1957 through the Treaty of Rome. We had Italy, Luxembourg, Belgium, the Netherlands, France, Germany, and I've missed one. No, I think that's it. So there were the founding 6 parties. 1973, Ireland and the UK joined. Then in the 1980s, we had the Single European Act. And this was the first real step to start breaking down borders, to try and create a single market. This was a really, really ambitious project when you think about where Europe as a continent had been only 40 years beforehand. And we were now at a point where they were talking about abolishing borders effectively between the different member states of the European Union. 1989, the Berlin Wall collapses, which brings Eastern Germany into Europe, and by default into the European Union when it joined up with West Germany. 1990s, we had more joiners. We had the Schengen Agreement, which was free movement of persons, the abolition of passports. Millions of students, including me, started to study in other countries. In the 2000s, we had the introduction of the euro. 12 new Eastern European countries joined. And then we get to this decade, and this is when it's getting difficult. We saw how the euro struggled through the financial crisis, how the institutions just didn't have the weaponry to deal with things as effectively as you dealt with them here in the US. We could only watch with a certain degree of admiration as to how quickly and how effectively your regulators moved here. We just couldn't do it in Europe, or at least the European-based regulators couldn't react in anywhere like the same way. And these freedoms that we had, which I'll talk about in a moment, particularly the free movement of capital, we began to realise the problems they brought. So for instance, Ireland was a country that has a population of 4.5 million people. And it had 3 banks, and they were great, and they loaned money out at a crazy interest rate, and that was it. And they had access to a pretty small pool of money. It was expensive, and as a result, it was expensive to borrow money. We then joined the euro, and suddenly it was like turning on a gusher. Okay, we had access to as much money as we could possibly handle, and we couldn't handle it. with the effect that we had the probably fastest growing property market in the world, and then the most dramatic property crash, even bigger than the one in Boston, going back some time, I think from peak to trough, and we're still figuring it out, something like 70% in Dublin in property prices. So that was the downside to the European project. And we've seen a growth of nationalism, which is worrying because it was nationalism that was at the root and was the rationale behind the creation of the EU to start with. We've seen a growth of national candidates being elected to national parliaments and to the European Parliament. And then, beautifully, we have Brexit on top of it all, which I'll talk about briefly. So the EU works is far from perfect. We have a European Parliament, which is directly elected. We have a Council, which is the leaders from each of the states, and their various ministers get together occasionally. We have the European Commission, which is really where a lot of the power lies, and that's the civil service. And that's a big beast that drafts all the laws and keeps things pushing along. And then we have the European Court of Justice, which is the ultimate court of arbitration on any matter that's EU law related. Cases get referred up on a very regular basis from domestic courts. The EU works off what are known as the four freedoms. And this is free movement of people, free movement of goods, free movement of services, and free movement of capital. As you know, we have 28 member states, of which 19 states are in Europe. Okay, so that's the European context. So if I bring that back to me, and back to Dylan Eustace if I can. When I was in college, I studied EU law. So this is back in the late 1980s, early 1990s, and I hated it. It was. I much prefer the cases about snails and bottles of ginger beer and carbolic smoke balls and Dunlop pneumatic tires, and then you'd go into your EU law case and it would be Commission versus Italy, case number 7 of 68, or Commission versus the Netherlands, which is case 2 of 92, or Commission versus Italy, which is case number 3 of 1980, and it was terribly dry and terribly disinteresting. But then I went to study in London, free movement of persons, didn't have to pay any tuition fees, thank you EU, studied there in college, had a great time, and came back to join Tiernan Eustace to practice EU law, because you just couldn't escape it. And I didn't actually realise I was practicing EU law, but that was the reality of it, because EU law had become, and has become so overarching in Europe, that it was pretty much everywhere. And how the British are going to untangle themselves from this web of legislation remains to be seen, but it is going to be a fascinating couple of years. So back to this big picture and to apply it to Ireland. So we're now in the 1990s, and the freedoms of capital and services are really, really kicking in. As you know, money is like water. It'll just flow along the path of least resistance. And traditionally, for years in Europe, it was countries like Luxembourg and Liechtenstein and Switzerland that attracted money. Back in the 1990s in Luxembourg, there were money counting machines in the lobbies of the banks for Germans coming in to hide their illicit gains, and that was the way things worked. But things were changing. And in Ireland at the time, we had a perfect combination of a visionary politician, who's now passed away, so I can also say a visionary corrupt politician, coupled with a visionary businessman who has not passed away yet, so I will say nothing about him. And they got together and created a very simple idea. They said, well, look, let's create a zone within the city. We've got these dock vans, you've seen it all before, dock vans, they're run down. We're going to create a little tax incentive area, and we're going to call it the International Financial Services Centre. That sounds good. $3.5 trillion later of assets under administration, more actuaries per capita than anywhere else in the world, all the aircraft that you could want to wave a stick at, and 40,000 people working there, and that's how the whole thing started. And what made it possible was the membership of the European Union, the fact that the borders had come down, and from a little country like Ireland, hanging off a rock on the west coast of Europe, you could transact international business, which meant that people like me could transact business that we would have had no interest or right of doing in doing 10 or 15 years prior to that. But coupled with that, of course, was tax, and this is one of the challenges. So if I was going to identify what I see as being the challenges to cross-border commerce, I'd say tax is one. And by that I mean that there is a significant, and you'd be familiar with this, there is a significant focus, as I think there should be, on fair tax and on companies paying their fair share of tax. And we have been guilty in Ireland of facilitating in being a transparent jurisdiction in not putting up barriers to companies carrying on business. Companies have been able to work in countries like Ireland and the Netherlands and Luxembourg and the UK and structure their tax products or their tax planning so they effectively don't pay any tax anywhere. And that day is coming to an end. And we can see that increasingly, the pressure coming to bear. And one of the advantages that Ireland has traditionally had is that because we had no industrial revolution, because we had no backbone of industry in the country, we could play with our corporation tax very easily. So we had, when the International Financial Services Centre was set up, we had 2 rates of corporation tax. We had a high rate for domestic business, and then we had a low rate of 10% for companies that were based in this low tax zone. And for years, the European Commission battled with us because they don't like this. They say, look, you should just have one tax rate. You can't treat different companies differently. And we said, okay, after long nights of negotiation, the country eventually buckled and said, yes, we will have one tax rate. And the European Commission said, fantastic, well done. What will that be? And we said it would be 12.5%. So we brought our tax rate, which was at 30%, was our headline corporation tax rate, and we just brought it all the way down to 12.5%. Because we could, because we weren't giving that much away. Our corporate tax rate shot through the roof because it suddenly became a place that was attractive to do business. And we have hung on to that through the depths of the financial crisis when the country was on its knees and the President of France was fingering at a meeting saying, you have to change that corporation tax rate and raise it. We have hung on to that. But around the edges and tax planning, inversions, all of that type of aggressive, if you like, tax structuring is under extreme pressure, and the days I think are numbered. You might be familiar with the Apple case. This is a big ruling by the European Commission. That is probably an indirect attempt to, by the way, one of the areas that the European Commission do not have competency over yet is tax. That is reserved to each country's own parliament, but they can tackle it indirectly through what they call state aid, which is where a country gives an advantage to one company over another, and it's all about creating a level playing field. So the argument here is that through a tax ruling that Apple apparently got in Ireland, they were given preference over other countries, and hence this big tax bill of 13 billion euros, which has caused huge amusement in Ireland because the European Commission said, well, in Ireland you're due 13 billion in back tax from Apple, and our politicians are going, oh, no, thank you very much. Which is, every taxi driver in Dublin is scratching their chin going, how does that work out? But it's an interesting time. We have other big risks, like geopolitical. You see it in Europe, you see Crimea, you see what's going on in the Ukraine, you see what's going on in Syria, Russian-US relations, and as I said, that growth in nationalism that I referred to. And then finally, briefly, we have the big spectre of Brexit. For a country like Ireland, the UK is our biggest trading partner. We trade close to 60 billion euros a year with them. We share a border We are the only European land border with the UK, which is between Northern Ireland and the Republic. The history there hasn't been too great, but has been sorting itself out. So what's going to happen there? It's the reaction in Ireland, not at the result, but at the decision by David Cameron to actually hold a referendum, was one of absolute horror. We're quite fond of referenda in Ireland, and one thing we have learned is that it's never about what's on the ballot paper. It's about everything else. And when he most incredibly naively put a yes/no question to the British people, I don't think there was an Irish person who expected it to go any other way than no. Still, it wasn't a pleasant piece of news when we all woke up on that Friday morning. We had our first clients in on the following Wednesday from London, looking to talk to us about moving, and there's been a pretty steady flow ever since. It is the most remarkable decision that we may see in our lifetime, and then all the proponents scurry off stage when we go and get stuff. Anyway, time will tell. So, Gary, I hope you know that is okay. Yeah, please. Yeah. Any questions?
Yeah. What is the betting in Europe about the bond business and the big banks in London? Are they going to Frankfurt? Are they going to Dublin?
Yeah, it's a very good question.
They're going, right?
They're going to have to go, because to operate within Europe, you need to have one of these European Union passports. To have a European Union passport, you need to be regulated by a European central bank, effectively. So that's going to be Ireland, Luxembourg, the Netherlands. And so, yeah, they're going to have to move. If they want to maintain access to the European market, they're going to have to move. And I think it'll break down along certain lines. I don't think any of the big banks will end up somewhere like Dublin. We had the European headquarters of Merrill Lynch had their European headquarters in Dublin. I don't think an Irish central banker slept for the entire time they were there, because the balance sheet was so big it would have blown the country out of the water. They ironically moved to London last year, which that may not be seen as such a good idea. So, and they gave up their office space, but they're not good. Anyway.
What do you think is going to happen to big London law firms?
Yeah, they're and I was down in New York yesterday, and that was a question that kept coming up. The view is they're stagnating as things happen anyway. That business in London has kind of plateaued out. The London law firms are starting to leave people go. One thing a lot of them did was apply for practicing certificates in Ireland, which is quite interesting. Ireland is obviously English speaking. It's a common law jurisdiction. So the only English-speaking common law jurisdiction left in Europe, we like to say. So a lot could look to Dublin as a place to carry on business. It'll be really interesting. I mean, they to date haven't really opened there. A couple of the smaller UK firms have, but they will be able to manage at the same time a lot of their business from London. But unquestionably they're going to have to move people like their antitrust lawyers, and they're going to have to move. It's interesting.
I want to follow these two questions on with one that relates to payments.
Mm-hmm.
So the UK, and by that mostly around London, has been one of the leading innovation hubs for virtual currency and faster and all kinds of new payment initiatives. And many people believe that will not be able, for many of the reasons you just cited, to stay there, in part because they will no longer be in the single European payment group.
Yeah.
So that they will not be able to stay. They will have to move that source of innovation. The people on our side of the Atlantic are thrilled with this idea, but it is certainly a business opportunity for Ireland and other places in Europe that remain in Europe, because many people won't want to go that far in order to have that same innovation hub opportunity that they've been enjoying for the last few years in Is that?
Yeah, I mean, the second firm we had in was an e-money transmission firm.
Yeah, that's not a surprise.
Yeah, and that's the kind of business that could move to Ireland because it's, it's nimble. There is that technology base in Ireland, but they would have no choice but to move out of the UK because they just won't be able to passport around Europe. Now, what they're focusing on is what's the minimum we have to move. So what can we have in Ireland and keep in the UK and still benefit from this passport? And that's unclear. The Irish regulator came out earlier this week and said we're not going to allow Breastplates. We need real substance, and that's just to be expected. So
Breastplates, you mean shell?
Yeah.
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 Let's thank Morgan for that presentation. We're fortunate that we have probably two of the few lawyers who understand Bitcoin on the panel. And Steve Chow's going to start off by addressing the question.
Water has been replenished.
Oh, that's good news. Can I have one? Thank you.
Well, I'm going to do a survey of some of the payment systems ideas that exist today. But as a preface to all of this, I actually note you mentioned the carbolic smoke bullet case. And that was actually one of the turning points of a lot of what we're talking about. That Amy Boss answered my question when we started doing UCC 2B as to what's the precedent for all of doing this what I used to call remote anonymous contracts, or what Jim White called autistic contracts.
Yeah,
You tie your shoelaces, you agree to my terms. And this is an offer to the public, and she said, well, carbolic smoke ball is the case. But the idea is that carbolic smoke ball offer a reward to the public as opposed to taking things back from the public, which is very interesting. But let me at least give you a little bit of an idea of what the Uniform Law Commission is. That it was founded in 120 years ago, and after the Reconstruction, to try to start looking at the idea of basically states' rights and what states could do. At that time, what we have is existing laws merchant, probably mostly in New York, and then we had the Uniform Sales Code eventually early on in the 20th century, and that took another 60 years to gel into what's called the Uniform Commercial Code. So our work is basically people proposing a uniform law, and we study it, and then we do a drafting committee that meets twice a year, 3 times a year for a couple of years. We develop a draft, and then it's debated among 300 commissioners. Usually not 300 show up at that floor because we have a continuous debate for 8 days, 7 days these days. And then we go back and rewrite things, and we come back a second time at least, and then we propagate it and go to an ABA and see if it's approved, and then put it out to states. And Professor Hughes is a reporter on one of those projects that was just mentioned. We're done with the first summer. We're going to the second summer now.
The second one,
Right.
yes.
So let me just point out, in terms of payment systems, traditionally, at least in our lifetimes, letters of credit were big. And this was developed in the UCC Article 5 in the 1950s. The International Chamber of Commerce came up with some other rules, what's called UCP 500. In 1995, when I was just there at the very last bit of this on the revision, Ed Smith, who you've seen before, was on that committee as well. Right now, we're sort of on the UN Convention on Independent Guarantees and Standby Letters of Credit. So this is a little different from many of our statutes are not self-executing. The treaties are not self-executing. So many of the commercial treaties recently, since the CISG, are not. And this has resulted in a major issue because at the Uniform Law Commission, we have talked about such things as what we call cooperative federalism. So the idea is that each state would have to approve the treaty to have it executed. And this is not going to get done. But there's some of the Federalists who feel that they have to do that. I'll mention one of the committees I'm on. But this UN Convention, for example, is one of those that are being held up.
Congress hasn't approved it yet.
No. Yeah.
For what, 8 years, Steve?
Right.
Yeah.
Right. I mean, that's it's an interesting relationship between Congress and other matters. I will mention that the Defend Trade Secrets Act, which Congress just passed in my view, for no good reason, but that one they passed because I guess because they said that the Chinese were stealing $480 billion a year and $2.1 million, 1 million jobs a year, and that encouraged them to press forward, ignoring what might be called tort reform. So this is a federal private right of action for what was a state unfair competition situation. But yeah, that's besides what we're talking about. So some of what was happening, and I come from a time where I was a summer associate in Chicago, and we did not have interstate banking, and we didn't even have branch banking. It was like in Indiana, you could only have a branch within 800 feet of your main branch.
Right.
So we were talking about a lot of...
And it wasn't very long ago.
Right. Right. So that's when I started. So roughly around this time of getting into interstate banking and other things like that, there was this thought about, gee, why don't we have a kind of a unified field theory? By the way, I'm a physics person, so I believe in dualities of particles and waves, so that some of the things that goods means a lot of different things to me than it does to most people. I think electronic stuff is physical. That's kind of my view. But anyway, this thought back in the let's say the mid-1970s about a unified payment system. And Hal Scott from Harvard was involved, as he reported it. He was completely frustrated in doing that. Congress came out with the Electronic Funds Transfer Act earlier, and it addressed to consumers. Meanwhile, we dragged our feet and we wound up with the UCC Article 4A, which is Professor John, you can certainly pipe in any time about that one. But the thought is that so much of what we do in the conferences, we try to do concepts like security procedure, and well, it could be algorithm, could be encryption. A lot of these things, technology was around it, but we didn't really pin ourselves down to any of it. It simply said that, among other things, that just comparing a signature with a specimen is not enough. So it's all completely open-ended what kind of security you needed. Well, the industry proceeded, automated clearinghouse, SWIFT, and SWIFT, I just gave a cybersecurity talk yesterday, and the Bangladesh hack. Well, no one really knows what exactly it is, but it is a certain lack of security on the SWIFT system. And in fact, something like $100 billion was supposedly transferred. It turned out that, no, I'm sorry, so it's $1 billion that was transferred, and they managed to catch most of it. So they only lost 50 million, I think. I forget, maybe the numbers are actually higher.
Something like that.
Yeah, something like that. During this time, the auto industry and others had looked at the idea of electronic data interchange. These are kind of words that were thrown around in the 1980s. The documentation of a lot of parts, they say it goes back to the 1948 Berlin airlift, but the automotive industry needed lots and lots of parts, and they had purchase orders that they're standardized. It could be peer-to-peer, that is between the seller, the supplier, and the buyer, or it could be in the value-added networks. Of course, the value-added networks made money on that, so they wanted to improve the whole idea of EDI. And consequently, there were two standards, a couple standards developed, the United Nations standard and the American standard, the accredited standards committee.
So just go back for a second. Go back to your slide, Steve. network is a term that sort of meant banks or people who were like banks.
Right.
Right. So the thing that's interesting here and that carries us forward is that peer-to-peer means I send money to Steve and there's no intermediary. And value-added network means somebody is in the middle because the two of us do not have the equipment to send money to each other. Now, from a 2016 perspective, that sounds like crazy stuff. Because everybody knows you can do that with lots of mechanisms today that you couldn't do 5 years ago. But in the 1980s, the idea that you would do this peer-to-peer in the United States, as opposed to in Europe, where it was better, but in the United States that you could do this was absolutely revolutionary. And Steve was probably right in the middle of it.
Well, one of the major differences between how there's several major differences between Europe and the United States. One is, of course, and I mentioned that I was part of the debate on the revision of Article 2 that all the professors came out from the 1988 CISG, and they wanted to change the UCC 2 to reflect that. And Dick Speidel and Amy Voss were people who were pushing this, and I actually sided with Microsoft and others to stop it. And part of it was the idea of the statute of frauds. And my argument in those days was that, well, we're not like the Europeans because we're much more litigious. So we want to encourage a writing more than they have. I mean, the UK abandoned statute of frauds, but we stayed with it. That's part of why we actually turned on CISG back in those days. We could talk lots about the CISG, but that was an interesting part of what was happening. So the other part about European, or actually the rest of the world, is that the statutes are quite different. I think laws are expressed more in terms of principles and desiderata that magisterial people can make a decision on, rather than the so-called precise statutes that we have that we can litigate on. And the lobbyists can change words on. And that's a major difference. The other one is that here in the United States, we encourage credit cards by allowing the $50 limit. And so everywhere else in the world, people went to store value cards instead of doing credit cards. So here, the credit card companies and other issuers can ensure the value of fraud. They say, okay, yes, it's a $50 limit, but they raise the rates in other ways to make the money. Other places, you do store value cards. And that's a major difference between what we have done here, electronic commerce-wise and others. But what was happening in the 1980s, early 90s, was the idea of public key infrastructure. This was something that the technology for all these encryption things has been around for a long time. In fact, I did some of the patents on these things way back. And the major idea of public key infrastructure is that there's an algorithm that allows you to create two types of keys. One which is a public key and one which is a private key. It's just basically two keys. And the idea is that you would give, but both would be able to encrypt or decrypt. So what you can do is that if you had your private key and you encrypted something and you gave the entire world the public key, then if you encrypt it using a private key, then if the public can decrypt it, then they know it's from the person who holds the private key. And another thing that was there was the idea of a one-way hash. That is an algorithm that takes some text, and it's a message abbreviation, and it's unique to message. So that if this hash matches, if you actually use the hash on the same text, it will always come out to be the same number. If the message is altered in any way, you can tell that it's been altered. So these two things have been very useful to develop something called a digital signature. So there, you use a private key encrypted hash, and then the other end is encrypted by a public key, and then that guarantees both the source of the information as well as the integrity. Now, so this idea is that this is a really good way of assuring that, this, whatever message you got, whatever signature you put in it, it clearly comes from the person who owns the key. The problem is how you compromise the key. So we try to build, people try to build a public key infrastructure and say we have certification authorities, and we have this authority that certifies all the keys. Utah tried to become the Delaware of electronic commerce back in the 1990s, and we went down that path. But what happened at the Uniform Law Commission is something different, and this actually went hand in hand with to say I'll give some credit to the Mass Bar Association. I was on a committee there that proposed something called UCC 2B, which basically was taking the word lease in 2A and plugging in license. And part of that was, the reason for doing that is I'm an intellectual property lawyer and I do licensing, and I found that for small clients I couldn't get people in other countries to agree to our terms. If I represent digital equipment, which I also did, then we could do it. So I thought that, gee, maybe we should have a uniform law on this. And it was a very different time, and whether software was considered a good or not, some of the cases back then said software wasn't good if it was mass market, off-the-shelf software, whereas custom software would be a service. And that was what was existing in the early 1990s. What we did, I mentioned that 20 years ago, we started UCC2B and Pro-CD happened. And Pro-CD, if some of you don't know, is a case that probably is a basis for a lot of what is called click-wrap contracts, and the idea of licensing without even having intellectual property license from, but just to restrict the covenant because you click. And on that basis, we had a lot of decent discussion about where UCC 2 and 2B would go in terms of talking about such things as the New Jersey Law Revision Commission's idea of having 2 layers of assent for, and this actually relates to CISG too, that assent for boilerplate versus assent for essential terms. But that died as soon as Pro-CD happened. There was no reason to deal because the publishers had the upper hand. But so during all this time, I was on both the UCC2B drafting committee and the Electronic Transactions Act committee. And the idea in the electronic transactions was very limited. It was that should we go to digital signatures, or should we be technology neutral, which simply say that, well, okay, we've stuck with this idea of statute of frauds, but should we make sure that electronics are okay, as long as you have some sort of agreement that you use those electronics. And so it's a very limited enabling kind of thing. Simply that, okay, well, there are a couple of cases here and there that said that some judge says, well, I don't buy a fax signature because I don't trust somebody that burps and chirps. And but it really didn't go that far. But in some ways, it was a foundational thing that we would have approved electronic signatures. And electronic signatures could be anything, basically fax signatures, clicking, putting some sort of intent on your email, that kind of thing. And meanwhile, Congress, again, got ahead of us. So they passed the Electronic Signatures in Global and National Commerce Act called eSign. And the conference managed, in those days, we got enough people who felt that, well, contracts is still a state thing rather than a federal thing. Or the technologists would say, well, why is it a state thing at all? Why don't we just do international contracts? And I was assure you most technology people think that way. But we still have this idea of Uniform Commercial Code and a state-based thing. So what e-sign did was is reverse preempted by the state enactment of a pristine UETA. I'm not sure actually that many states have a pristine UETA, but everyone has labored under that, or not labored, but just proceeded under that presumption. But meanwhile, what's been happening is that the UN ECommerce Convention is another one that was not, that we signed, but we have talked about whether we, should we do it by cooperative federalism or not? And the committee, the UETA committee, was reconvened, and we kept coming back and saying that, come on, we're not going to be able to go back to the states and pass another UETA. And there's a difference in the sense that from the UN side and the European side, there's much more concern about consumers than we have here in the U.S. And so the UN Commerce Convention does not address consumers at all, whereas UETA actually looked at consumers to some extent in the classification of things as mass market. But some of us were willing to go by and say, well, come on, we're not going to go back to the states and try to get this enacted. So what's happened? Well, so I would say that for the past 20 years that things have proceeded on the electronic commerce side, on the contracting side, mostly on the old case of GoCD and Sprecht against Netscape, which was to say that most click wraps and even browser wraps, there's things that are sitting on top on the website that says that if you use this website, you agree to all my terms. There have only been 5 cases up to about 2 years ago that was challenged, and then the challenging was primarily on consumer arbitration costs. In the past 2 years, I think there have been something like 25 decisions on this, most of which are still consumer arbitration, but some of which have crossed over to B2B things. And so it's interesting whether this concept is going to be challenged or not. Well, in the meantime, what's happening in internet payment systems? PayPal is one of the big ones, as essentially a payment intermediary. It's not a bank; it doesn't keep deposits as fractional reserves, and it's state licensed as a money transmitter. There's some regulation needed that applicability from the Electronic Fund Transfers Act. Some merchants use it to avoid credit card record keeping because of the privacy laws and especially the data breach laws. So you say, well, fine, we don't keep all those credit card numbers around. Whether that actually works or not, and they just have PayPal deal with it directly. And of course, there are mobile systems that come up: Apple Pay, Google Pay, and Samsung Pay. And they all have somewhat different approaches. One of the things that has been going on in this is something called TransferWise. This is a peer-to-peer money transfer service that started in 2011. Has become fairly popular, and it's not such a great leap, but the idea is that the sender's money is redirected to the recipient of an equivalent transfer, going in the other direction. And their license of the money transmitter, Professor Hughes has tabulated the number of.
We started scratching our heads about how this was, and the 53 jurisdictions could issue a license to TransferWise. And what did I decide? 20 to 25 have.
Right.
So far.
And this is actually compared to a sort of traditional Arabic way of trading.
Hawala?
Yeah, right.
Hawala.
The idea is that, okay, so you call up the person on the other end and say, well, you credit here and you go credit there, debit there, and that's one way of doing it. So this is something that's been happening on the internet. I mentioned.
Isn't that kind of like how banks started in Europe?
Yeah, I think that there are different aspects of how they're
Right, but
yeah.
it was
like
that
a letter
same
of
kind
credit.
of,
Yeah,
it's
like
like a letter of credit,
letter of credit,
exactly.
Yeah. And one thing, I think you raised the thing about supply chain finance or supply chain. This is a idea that large companies seem to be using. Large companies that have a lot of good credit rating. So then what they do is they do what's called reverse factoring. So the ordering party initiates, usually in the factoring situation, a supplier wants, needs working capital when they want to pay their order. So, instead of waiting 30 days or 60 days, they may sell their receivables to the factoring company and they would get the money. This way, the idea of supply chain reverse factoring optimizes things a little bit because if the ordering party is like a really big company, it's good credit, and has many suppliers, they can say, well, fine, I'll get the credit at a low number, and we'll just pay off the suppliers, the ones that we want to pay off. And that's been the people who've been running, the factories have been running these things have been saying that, oh yeah, this is replacing letter of credit. I don't know if that's entirely true, but for some large companies, it is an optimization of how they do things. So the idea of letters of credit and all these intermediaries is that people, margins are so thin in so many industries that people just want to get rid of the intermediaries. And it could be that factors in a certain kind of intermediary, but it's not instead of like the kind of two bank intermediaries that you get two people dipping into this. So what I think is exciting is the whole idea of Bitcoin or blockchain. The blockchain is actually the more basic part of it. Blockchain has actually been around since 1994, but it's because Bitcoin it got a lot of attention. And the idea between the blockchain is that you would have a single ledger. Instead of having one bank having one ledger and the other bank having another ledger, and settling between the two is that one bank debits and the other bank credits, and the clearing between the two might be through someone else yet. The idea is that you would just have a public ledger. And the public ledger is, how is it authenticated? It's authenticated by a certain kind of encryption system, and this tracks every transaction. For example, in Bitcoin, every movement of a Bitcoin and cutting it up and sending it somewhere else, all of that is in this huge ledger. And I understand the current size of these things is like 4 gigabytes. And so it's pretty large. So the idea of using Bitcoin as a virtual currency is to register every transfer. And Bitcoin in a particular situation is the idea is that if you have several competing, each ledger includes encrypted transaction history of what went before. So you just have a bigger ledger, and the bigger ledger is authenticated by the public in some way. So this is consensus of what that, and here's some of the other kinds of virtual currencies out there. They all work on this. Bitcoin gets consensus of what's called proof of work, that is mining. And what this means is that during a certain period of time, 20 minutes, whatever, everyone on the network can vie to do this proof of work. And if you do the proof of work, then you get some reward, like transaction or it's called Bitcoin mining. But it's this kind of strange sort of thing that they use, which is to say that we'll encrypt, we'll get a hash of the total ledger and some other value such that the hash has to have 5 zeros in the beginning. And so it's easy to verify if they reached it because you can get 5 zeros in the beginning. But it's incredibly hard to go through 5 gigabytes of stuff to come up with this number that in the hash would turn out to be that way. Well, the question there is that it's reached a level where this may not be scalable. for the 20 minutes it takes to do this auction and to have a lot of computing power. As it gets bigger and bigger, you need more and more computing power. The computers have been pooled, and it turns out the Chinese are doing a lot of this. And in fact, one of their entrepreneurs has a special chip to do Bitcoin mining, to do this thing, and selling it here in the U.S. But it's we'll see whether Bitcoin gets very far. It's been accepted so far in many ways. Like Amazon would take Bitcoin. There's a Bitcoin transfer machine.
At South Station,
right? Yeah, and but a lot of the bigger players, they don't take that risk, and they just want to be ahead of and say that we're cool, we have this stuff. What I've been finding is that hearing stories about is that Bitcoin's getting some push because of what's called ransomware. So the idea is that someone locks up your computer by putting a worm in it and says, okay, pay me $2,500 or $25,000 to let you access your computer again, but pay in Bitcoin. And so people go on and get Bitcoin to pay the ransom. So we'll see. The other one that touches on some other issues that we are looking at is the Ethereum network. It's a different type of consensus. It does it by tokens and value. And the very famous, it's not even a hack, but famous development, and it's just back in June, was there was established the decentralized autonomous organization. And what it was, I think it still exists, but maybe not, is a crowdsourcing idea. So you would, in some way, put in a token, and it would be in ethers, which is what Ethereum is. And they put some computer programs into the blockchain, and this would be authenticated as others. And the idea was that it turned out that they collected a fair amount of funds, but somehow someone set off the conditions of the program or the conditions of the contract, and it paid out $50 million. And however, some of that was in a place that was allowed to be blocked, and what we say in the computer business, there's a forking that some of the players decided that we should live up to what we said, that these things are completely autonomous and automatic, and you can't call mulligan, whereas a good number of people would call mulligan to recover the $50 million. So we'll see whether that goes, and this is kind of a black eye for the idea of smart contracts, but we'll see. There are other ones that Ripple was a social network agreement on the consensus trust, and R3 is another consortium thing, which a lot of the banks are beginning to look at very carefully. So the banks on the banking side, there's a great threat to the back office IT people. So the reality is that margins are thin. The owners, shareholders want to cut back on all the IT. One of the big issues with most banks is that they don't have compatible forms. And this is why the idea of having a single ledger is, a single common ledger is appealing. And you get rid of a lot of the IT people to try to make sure that you get conversions. On the other hand, this may have some legs to get there because it's a lot of money for the big banks, but it also is some opportunity for smaller banks who don't have the IT staff and maybe could find some technology approach to this. So now this brings us a little bit to the stuff that Professor Hughes is working on, and part of the idea of virtual currencies is that they're wallets. When I'm talking about 4 gigabytes of stuff, not every person is going to have a computer that fits many 4 gigabyte things and does all the calculations.
Steve, Maybe nobody in the room other than you.
No, I don't have to get it. So there's key management. So the idea is that you may want to block against someone just stealing your key and really invading your system. You may have 2 keys. So you need both keys and it may be in separate places before you unlock things. However, if you lose one, then you're dead. So the idea is that, well, maybe you have 2 out of 3 keys can open. And there are a lot of mechanisms for doing this. And there are service providers that purport to do this, but there have been some of these storage firms are maybe regulated. So some of the regulation of virtual currency, the FTC settled bogus Bitcoin mining operation. That's just pure fraud. And then there's others that, and there's CFTCs that these virtual currencies come under commodities. Again, we blur the line between what is physical and what is virtual, let's say. But what happened was that New York decided to create in its codes, rules and regulations, a virtual currency regulation, virtual currency business regulation, not the regulation of the virtual currency itself, but what kinds of businesses are allowed, whether businesses are allowed to be regulated. So consequently, this brings us to the project that Professor Hughes is working on, the uniform regulation of virtual currency businesses. And of course, one of the issues is what's virtual currency? And this at the annual meeting, of course, no one knows. They're talking about this ranges from your frequent flyer miles to your game, your Warcraft currency, et cetera, et cetera. And this is the kind of stuff that we at the Uniform Law Commission sit down and try to vet and come up with things. You have anything about that one? So
most of it's virtual these days.
Right.
You don't have much of what you own that you would call money in your pocket, do you? So it makes it more complicated to distinguish between bank money and this.
Right.
Right?
Right. So another committee, this is one that I'm on, is pulling together some of the old UEDA folks on the study committee on identity management and electronic commerce. Now again, this is an area that honestly the UN Commission on International Trade Law has proceeded. In fact, the European Union has already had a regulation on this, just issued a couple of years ago. And this addresses, again, sort of conceptually, what kinds of things you need to assure that things are identified or authenticated. In the meantime, and on Article 9 side, of course, there's the idea of basically electronic bearing instruments and documents of title, that sort of thing. And it had always been a problem. You can have a book entry system that identifies who has what asset, but if it's a bearer instrument, how do you say electronically? How do you say this instrument is identifiable? Well, we now have some technologies, including basically consensus authentication or multiple date stamp things. And there are a number of things to get there. Now, the question is, one question I come up with is, should we leave technology neutrality and go adopt some of these technologies that seem to be out there? And, my answer is still probably not. And but that's we'll see. This is what's happening as we go on. So and Congress, interesting, they started to work on the e-sign, and they're doing a study draft that mentions the idea of blockchain and mentions the idea of smart contract. I don't think it's gotten anywhere yet. It would not quite do the same technology neutrality as e-sign, because all e-sign said was that if you do a signature with some intent it's not a physical signature, that you can't reject the contract because of that. This goes a lot further and starts saying that, well, these things can be treated as electronic signatures, and I'm not sure that that's necessarily the case, but so they're thinking about that, and I guess we'll have a lot of debate on what these. Again, smart contract is since the June debacle on DAO. I'm not sure how far that's going, but there are other kinds of things that are going on right now, especially in our business of law. The idea of automatic document assembly, that is, automated form contracts, etc., and piecing together different terms. People are using things like predictive coding, which is going through a company's information and all their contracts and doing predictive coding and finding which ones are the most relevant and that kind of thing. Then there's the idea of open source contract development by seeding a contract and then having the open community reiterate and get this thing better. Common Accord is this is Jim Hazard's thing. Jim being Jeff Hazard's son, and so he's been doing that. So this is some of what's going on out there that can be used in as virtual currency or as payment systems. We have in place a number of different systems right now, and I think that among the big players there probably will be some change to this because they want to make it more efficient, and that probably is some kind of ledger situation.
Thanks, Steve. Let's move to the regulatory side.
This is your factual question. So President Obama just submitted to the Senate for advice and consent the Standby Convention, the Electronic Commerce Convention, and the Factoring Convention. Is that just, let's get these off my desk before I leave?
Yeah,
is there anything going to happen with them? Do you have any sense on that?
I think Congress is going to do it. They're not being cooperative.
Okay. No, really.
So I think Commissioner Chow is correct, but what I think there are people in Congress who simply do not like the idea of the United States giving any authority to a multinational organization in the sort of high form of objection, and they normally can table any discussion of it. But I think the President has been eager at least to make it, to have one more try. And I agree with Commissioner Chow, it's not very likely.
Well, the United States doesn't like to hear anything about UN. And the idea is that, look at the turnover of ICANN, and the domain name service to leave the NTIA, and there was a lawsuit brought to enjoin it, but the judge denied the injunction, and now it's since October 1st, ICANN is now no longer controlled by the Department of Commerce.
So, sir, would you like to?
I think I'll stay right here because I can actually see people better here. Then I will if I stand over there, because then I'm worried about this post. So the task for today was to talk about the sale of goods, and if you're going to talk about the sale of goods, you have to talk about payments. When you want to talk about a cross-border sale of goods, then you have different payment issues than you would have, and you're going to be able to tell in the next 15 seconds that I'm not a physicist like you, that I'm just a person. All right? But there are things that are common to both domestic payments and cross-border payments. And they are things like getting authorization, as Commissioner Chow was just describing, determining when a payment is final, so somebody knows they can go spend it themselves, determining when an obligation, that is a sale obligation to be paid a price, has been discharged by the payment of the price. These are things we all care about in our everyday life, and everybody in international trade cares just as much about them as we do. We want to know when our paycheck hits our bank account. And the same thing is true if I were in the business of selling something that I wanted if I have them covered by a document of title, I want to know that I've been paid before I give the document of title to the buyer. So these are old line problems that are now capable of being addressed in very quick ways to some extent. So if you go to Christmas shopping, the credit card company can, by design, speed up the time it takes to authorize your payment, and they simply decide that they will accept a little more fraud loss. Then they complain about the fraud loss, but that's another problem. They can do that, but the way the banking system currently moves money, especially across international borders, could only be described as slow, slow, slow. And the manner in which people want to do business and the kinds of things that they're trading in, particularly in financial services and trades of financial instruments and the like that have been going on and moving so much to Ireland, makes this a very complicated question. We also want to know if we place something of value with an intermediary, under what circumstances we can get it back, and how quickly it will come back to us if we want it back. So if you use a blockchain-based system as opposed to a bank-based system, here are things you could achieve, assuming you were willing, and the other side was willing to take a payment this way, because as Steve just said, some governments, many governments, do not think of virtual currency as money. It's not legal tender. You have to bargain to decide to take a payment that way. Otherwise, I take a $20 bill out of my purse, and you're required to take it because it's legal tender in the United States. Among the things that we would want out of a system that would enable cross-border trade better would be faster movement from the buyer to the seller across a border. A blockchain-based payment system, or indeed a credit card or debit card system, works pretty fast. In June, I went to New Zealand, and I had a Boston-based bank. Well, they're not just in Boston, but a Massachusetts bank with which I have a relationship. I had their debit card, and I thought to myself, my debit card didn't have a chip, and I wasn't sure that my debit card was going to work in New Zealand. It did. But I was surprised because it didn't have a chip, and most parts of the world use chips as an authentication device, an authorization check, and things that we care about, because we don't want somebody to go in and just take all the money out of our bank accounts without our knowing it, which was the subject of a huge fight that ended up in the First Circuit in Massachusetts in a case called Catco versus Ocean Bank. And there have been some others this is Stevens' terrain, Article 4A, and the courts do not understand Article 4A. I would say you can disagree with me.
I think you're right.
Okay, so there are other kinds of problems when you use a non-bank system. And some of them are the disintermediation from the banks, on which the government relies on banks to provide them all kinds of information. It's a tool for monetary policy. It's because banks have been so beholden to the governments that gave them charters, the government imposes anti-money laundering controls, counterterrorism controls, what a friend of mine who used to work for the Office of Foreign Assets Controls at the Department of Treasury calls foreign policy law enforcement. Blocking groups from getting monies or moving monies through the United States or persons like drug kings that we don't like. So foreign policy law enforcement often takes place because we have our hammer lock on banks. We can impose significant penalties on them if they do not perform. What that means is if you disintermediate payment transactions from banks, You lose your most visible, easily reached customers to give you information and to impose blocking orders. And you open yourself up to problems with things like transfer pricing, which is a taxation and money laundering ruse, because you don't price the goods the same way as you would if you were doing a domestic deal, and somebody can make a lot of money on the other side. Anything that is not an intermediated payment also creates a risk of contributing to capital flight. You've been reading in the papers about Deutsche Bank moving $1.5 billion a week out of the Russian Federation for several years. I can't count that high. You can, but I can't. So what then you have is, and the more anonymous the payments are, or pseudonymous the payments are, which is typical of a Bitcoin transaction and not of a bank transaction for the most part, the more you can have sovereign wealth move or capital flight, in addition to making cross-border sales transactions so much easier. So there are a couple of different movements in the United States, and I'm only going to take one more second to talk about them. There's the Federal Reserve banks have convened, and I'm serving, and someone else in the room also may be serving, a group called the Faster Payments Task Force. The goal is to create by consensus a series of faster, still secure payments, not all of which will be operated by banks, but which will receive a certain degree of blessing from the Federal Reserve banks. One or more of which they may adopt as a competitor to FedWire, and SWIFT is a different kind of system. Faster Payments Task Force has created some faster, secure, and legal principles that will be used to choose some of the eventual winners of this strange competition from 19 finalist products currently being vetted. And it's an absolutely fascinating process to watch. We also have classic risk management, and we certainly have seen hacking incidents or embezzlement incidents involved with Bitcoin transactions and other blockchain-based transactions, as Commissioner Chow was describing. So we have all sorts of classic, contemporary business problems, privacy problems, identity problems, authorization problems, cybersecurity problems, and to cycle back with Commissioner Chow for the states, and then to talk about it from another perspective, we also have this state-based licensing system for non-depository providers. We also have state licenses given to people who are banks, credit unions, pawnbrokers, money transmitters, and the like. People complain that it seems so odd to have this state system, but the fact is Congress has shown almost no inclination to step in and provide some broader platform for people to operate. So PayPal is licensed in 53 jurisdictions, TransferWise in 25, and the licenses are a little different whether you're serving as an exchange, you're just doing transfers of money or of virtual currency, or you're offering to take some kind of custody and store valuables on behalf of somebody else, which is kind of like a trust company, if you want to think about the models that we've had. Each of these kinds of entities exists in Ireland, in the UK, in most of the other advanced economies have systems like this. But think about all the economies where people don't trust banks, where there is no bank within hundreds of miles, and you can imagine that there, in addition to mobile payments, which are very popular in Africa, you could revolutionize the delivery of some kinds of financial services to people who don't have as much access as we do. We're slow because we have so many choices now, and the goal would be to give more people access to financial services, but it's only going to work if it works. And if people don't lose their money when they have a problem with authentication or in the transfer doesn't get there on time, you may lose a valuable bargain, you may be subject to consequential damages, you may have all kinds of things that will not, you may be sued, you may have all kinds of problems. It's a huge challenge. The banks are embracing it, not for payments, but for record keeping. And you can't think of the blockchain as being payments only. It has enormous record keeping, displacement, and enhancement opportunities embedded in it. But if you want to talk about those, you have to talk to him, because he's the physicist, and that's how this works.
Do you have any perspective from the European side?
Yeah, I'm not sure that Europe is any way ahead of the US on this. I think it was only this summer that the European Parliament suggested a working group on cryptocurrencies and digital currencies, and the European Banking Authority, and I think the focus has been on money laundering, and that's it. And even with that, there was a suggestion by the Commission that they would draw the firms involved in digital currencies into the money laundering directive. And the European Banking Agency came out quite strongly against that, because they were concerned that this might suggest that these entities were regulated in some way. There's everyone, but they're not. You know, it's not real money, it's not fiat money, it's property, and so it's really early days. Really early.
But a question for the panel might be, like, where are we in terms of people using Bitcoin? You see just a typical business-to-business transaction.
Well, why don't we ask, does anybody use Bitcoin? Okay, so we have a sample of 50 people who don't use Bitcoin. Because I'm working on the project, I'm not using Bitcoin. I don't think that would be a proper thing to do. But I have a co-author.
Steve gets his retainers in Bitcoin.
Yeah, people do get retainers in Bitcoin, and people pay for real estate transactions and do all kinds of things in it. But it has to be bargained for. It's like deciding that you're going to take a payment in yen. You've got to work the deal out if you want to do it that way. So I know people who do huge amounts of business in Bitcoin. Does the average American, there's a bakery in Portland, Oregon that will sell you a slice of pie for a slice of a Bitcoin. And there are places like that around. Overstock.com takes Bitcoin. I don't do business with them, but you can. I think it's just exotic.
Yeah, my sense is that there's a coolness factor, but there's also it's also the speculation side. I mean, it's fairly volatile, so you can make and lose money pretty quickly.
I think Lisa had a question.
Yeah, so and you may have covered this, but this is all new to me, so excuse me if you have. But so how do you determine the conversion of this? I mean, this seems like a global currency, but ultimately it translates, if you want to cash in domestic currency. So who sets the conversion rate? How do you figure out the value?
Instead of a government doing it, that's one of the differences. A fiat currency, the government, this is a really, really old English case that I just love. There is a case in 1690, and it was about Ireland. It was about Ireland. The Queen Elizabeth decided to devalue the currency, and somebody insisted on being paid in gold, and the court, not surprisingly, because she was pretty thorough in her power, the court came back and said, no, there's something about money, legal tender, that's the prince, that was Elizabeth I, the stamp, I get to control what the thing looks like, so I know when it's real, and the value. So all of these years, back to Rome, back before Rome, the government controlled the physical representation and the value. A market-based Austrian economy model of money is not the government, but the marketplace doing that. And so these conversion rates are a lot like commodities transactions or like stock transactions. What the last guy paid pay for it is what you get.
Yeah, I mean, because
I'm right about that, aren't I?
Yeah. Because the ledger in the Bitcoin, because the ledger is available publicly, you know, you can see, you know, if it's been transferred out in return for some value. So the market's, you know, it's pretty quick. You can find a market value pretty quickly.
So if you went back a couple of years prior to the collapse and eventual bankruptcy filing in Japan of a Bitcoin exchange called Mt. Gox, everybody may have seen that in the paper. The Bitcoins were trading before then in a band of around $1,000 to almost $1,200. And then it just like fell off the edge of this table and went back down to, all the way back down to about $150 for a while. And it's been inching its way back up. Some of it is because speculators are interested in controlling these places on this blockchain represented by Bitcoins. And some of which is just because some people are more comfortable or less comfortable, or some government, like China says, at the $1,200 mark, China said, oh, you can't use that to make payments here. Ding. If I had a stone, I'd just drop it off the table every time this happened. But what I think is so fascinating about this is it's market-based. So if you wake up tomorrow morning and you don't like Bitcoin, you're not going to pay as much for it. And that means nobody knows. Stephen said it's highly volatile. Nobody knows, which means if you're doing a transaction between here and Ireland or vice versa, this may or may not be a good way to do your transaction. And I don't know, in Europe, right now, in the EU, or at least in the Eurozone, this wouldn't be the same problem that it would be outside the Eurozone, would it? Or
Well, if you're, you wouldn't have the currency risk.
You could still have market risk, but you wouldn't have currency risk. So remember, we're always dealing with market and currency risk when we're doing cross-border payments. So sorry.
This is just fascinating. I have like 300 questions. First of all, if I can do two short, what's the authentication mechanism with Bitcoin?
Oh, the authentication is the idea that there's an auction in each of these cases of who gets to designate that what's public, which version of it is the controlling version. Because there may be some different...
I didn't ask my question very well.
Okay.
I meant, how do I verify that I'm the holder of the Bitcoins that I want to trade?
You have a credential.
Yeah.
There's some kind of...
And your credential is a really long algorithm that looks a whole lot like an email address. See, I told you I wasn't a physicist.
Okay.
But you have your private... it's like an internet location, and you have authentication. You have a key. So the question is, if you lose a key, it's gone.
It's gone.
You know,
that poor guy who lost his hard drive in a dump in the UK,
Right.
he lost his Bitcoin. So do you have a safety deposit box? Okay, so this is like a safety deposit box. The bank has a key, and you have a key. And they won't let you in until you show them your key and you sign in that you're you, and they'll do a signature comparison or something else. This is all algorithmic comparisons of whether the right key for the other piece and the private key come together.
Right, and also, as I said, we split up the keys, so this is like the safe deposit box, having two keys to open it. But that's led to other problems, because if you lose one of the keys, then you still can't open it. So now they're doing things like 2 out of 3 keys, or 4.
That thing is called multi-sig.
Right, multi-sig, right.
Multi-sig, and so you would not be as likely to lose for all time and all purpose your own signature key if you used a service that would hold your credential until you wanted to use it.
And these are the things that are being regulated.
Yeah, these are the things. These are the services that the work piece I'm looking at is trying to think about are exchange, that's fiat to market currency, transfer, that's like moving money through banks, and storage. Should these people be regulated in the same fashion? Are their functions different enough, like trust companies and banks and securities firms or commodities firms? Are their functions sufficiently different that we should tweak the way in which they're regulated to suit the kinds of roles they've carved out for themselves in this new marketplace.
We'll ask one of the questions privately.
Well, here's a related question. To use Bitcoin, I need a private key.
Yep.
Every transaction is on the blockchain. So to what extent is my use of Bitcoin anonymous, or as you put it, pseudonymous?
Well, I mean, the reality is that there's enough information flying around here, someone can triangulate you. But, on the space, you're anonymous. You just have a IP address
Number.
and number.
A very, very fancy IP address is what you have. The New York bit license to which Commissioner Chow was referring has a requirement like your bank does to know your customer, and that caused no end of consternation in the virtual currency community, because they believed that the money, the funds, the value should move anonymously, and it is possible to reconstruct. A few people tried to reconstruct the Mt. Gox transfers that they claimed were hacks, and they have debunked to a degree the hack aspects, and they think, oh no, it's just an embezzlement. The guy allegedly did it.
And there's a balance between money laundering and anti-terrorist stuff, anonymity versus that dark web. I don't know where this debate is actually going.
I don't know that we will not know for some time.
Yeah.
Right. So in the EU, there is the anti-money laundering directive, and it has many things in common with our rules, right? Applies to banks, applies to some people other than banks, just like ours do.
Yeah.
And so if you then tried to make a jump this way, you might do what they haven't done yet, but I do expect them to do at a certain point, to make a jump like New York State did and require comparable systems, but they're not regulated yet, which is why people were flooding to the UK to do these projects. But now they're all going to be there in Dublin with you.
Possibly. Yeah, but they would. And that's going to be another impact of Brexit. So you'll have dual regulated entities, because the Bank of England will continue regulating in the UK, and will probably shadow a lot of the European regulation in any event, just leave out the bits they don't like, and then you will have the EU regulation.
So we of course get criticized in this country because we have a dual regulatory system. We've had one from the very beginning.
Yeah.
People complain about it all the time. And in Europe, they have spent the last 30 years, roughly 35 years, trying to make a single unit that prints the stamp and the value, plus a passporting system that worked really well. And in the project that I'm working on, I'm trying to do two things. And I will mention them both because they're both fascinating. We're trying to borrow a page from the passporting system. We used to have compacts of banks in this part of the country that could do business across border as long as they didn't do business with New York or things, bad people like that. And then you also have I think I just lost that second piece of that. I had a concussion in May, and it's working sort of in here, but every once in a while it goes completely off the table like that stone I threatened to throw. The way in which these issues come up are classic questions of payments, and they're classic questions of whether you use a trusted entity or not. If Stephen and I both owned Bitcoins, we wouldn't need an intermediary. I would send a message to the people doing the verification. I would say, transfer 1 Bitcoin to Stephen. And the verification is not a trusted intermediary, it's just bookkeeping. But if I want to send money to Lorcan, either through a bank or through Bitcoin, I may need to use an intermediary. And people at Coin Center, which is a think tank about virtual currency, they told the Uniform Law Commission 2 years ago that in their view, if the thing quacked like a bank, It should be regulated more or less like a bank, or quacked like money transmission. It should be regulated like money transmission. And every morning when I wake up, I remember that line, and I keep thinking about how that influences where this project is going.
I've heard some people argue that, well, if you regulate, that means that in order for somebody to participate as an intermediary, they're going to have the resources to comply with those regulations, which means that, little startups.
Oh, that's my second point. Oh, brilliant.
I found it in Florida.
You did? I dropped the stone, guys. Okay, so the second part of what we hope to do is to create what we're calling an on-ramp, or a provisional registration, which is not a full license, but it allows, both academics to do some work without risk of being prosecuted by the federal government for engaging in the unlicensed money transmission business under 18 U.S.C. section 1960, and it allows startups who may have, the people who are doing this out of garages, the opportunity to test in a market the fact that they can actually do this and attract some business. So that second, thank you. That second piece, oh, that's it, okay. The second piece, the on-ramp, is controversial in some respects. Getting it tweaked correctly is highly controversial. But as far as I wouldn't have taken on this assignment, not because I don't love Stephen and his fellow commissioners, because I do. I wouldn't have done it if I didn't think I could do something that would enable the innovators in this space, in this country, to make contributions and have a safe place to do it. And it seems strange you have to go under a regulatory umbrella to get a safe place to do it, but you do in Ireland, don't you?
It's not particularly safe, but as we found out when they fell asleep before the crisis, but you pretty much do, yeah.
Yeah. So if we have to find a way to create that regulatory umbrella to allow more innovations to happen in this mode, well, I'm for it.
Well, I think that's an extremely positive note that we should wind up here. So thanks very much.
Now, this has been a tremendous afternoon. Again, thanks to each of you for the excellence of your contributions. Heartfelt thanks. We've got a few sweets over here. I know the other was wholesome and healthy, wise choice, but this is more the, indulge yourself. So network, have some cookies and cake and so forth. And again, thank you so much.